Hello and welcome to Defense Diaries. I am Bob Motta, your host, and for tonight, your moderator. This is part 2, and I'm incredibly excited about this, of the Richard Allen debate. So we're obviously talking about the appellate briefs that have been filed. So we've had Allen's brief filed, and then we had the state's response. And if you've missed the first part, you should go back and watch it. But this is going to be the next two issues, the last two issues, which we couldn't reach in our first debate. And once again, I'm joined by the brilliant Andrea Burkhart, the brilliant Allison Motta, and the brilliant Michael Ausbrook. Three brilliant legal minds. I feel very fortunate to have them give their valuable time to me in terms of us being able to go through this exercise, because I think it's educational and I think it'll be entertaining both. And I think it's a pretty neat format. So I hope that you guys enjoy it out there. I did get some comments that I wasn't as strict with the clock as I should have been. And, you know, look, if somebody's in the middle of a thought, I'm going to let them finish it out. Right. So I'm going to try to keep people to as tight as the time as I can, but look, there's no guarantees. And so it's going to be the same rules. Yes.
I was just going to note, and since Andrea and I are sharing the defense team, we have already spoken about, if Andrea's got more to say, that we're going to oblige. Okay.
So, because usually I was kind of addressing it to both of you to leave it to either one to kind of take the lead on it. Do you guys, I just want to be clear on this. Do you want me to address it to one or the other?
Yes, that's what we've decided.
Yes, please.
Okay. All right. And if I address it to the wrong one, then the other one say, no, you know what? I'll let Andrea or vice versa handle that one. Okay.
We'll do our best to read the room.
Okay. Excellent. And then, so it's going to be the same rules. There's going to be 5 minutes on the original answer. And then there's going to be, I think I gave 2 minutes on the response and then 1 minute on the sir response. Do you guys want me to up that time at all? Or like, did you feel it was too tight, especially on like the kind of the sir reply / sir response type thing? Did you guys, was it adequate?
Yeah.
Yes.
Yeah.
Okay.
I don't think did I go over? I think
no.
Last time?
Everybody was.
Michael the Pro is like the only one who didn't go over multiple times.
Yeah, you were pretty good with the clock, man. I have to say you really were. All right, so let's get started. Again, I am Bob Motta, and I'll be moderating tonight's debate. And as I said, we're picking up rather where we left off, which is issue 3, which really revolves around the evidentiary issues that took place, obviously pre-trial in terms of Judge Gull's rulings, and then obviously a trial itself. So, all right, I'm going to address this first one to Allison, okay? And this is the question. So, Allison, the Blair sketch. The state says that Blair never identified Allen as bridge guy, so the sketch is irrelevant to an identification that never happened. It's a pretty clean argument. What's wrong with it?
Well, first of all, I'd say that it's completely circular logic, because they absolutely do argue that because Blair saw bridge guy, you know, I don't care what you call him, fine, bridge guy on the platform, and it's around the window of time that Allen says he was on the platform, that Blair, by implication, saw Allen. The argument is logically incompatible with the state's own closing argument, which told the jury Blair must have seen Allen on the bridge because Allen told the police he went to the first platform exactly where Blair says she saw bridge guy. So the state can't simultaneously use Blair's platform sighting to corroborate Allen's presence at the scene at the relevant moment, and argue that her description of that man she saw, and then argue that the description of the man she saw is completely irrelevant to Blair's identity. I mean, if Blair's sighting is probative of Allen's presence, as the state did argue in closing, then Blair's description of the person that she observed at the moment is directly relevant. Now, there is the question that the state raises about waiver, but I think that this goes to a larger due process argument. I think that Andrea has touched on this in our other arguments, that there are, I think, due process windows that would open the door up to considering this. It was highly litigated. I think at outside of the jury, and unless I'm actually wrong on that, I think that it was that there was absolutely an attempt to made obviously at some point, either pretrial or on whatever basis. But when she's coming in saying that it's a 10 out of 10 for accuracy, and the visual character allows the jury to directly compare what Blair actually saw with what Alan looks like. And I know what the state's going to argue, that, well, it came in, they heard everything. They heard that he was this old and he had foofy hair and this and that. But it's different when you see that sketch and the visual character of it. I think that it is not something that is already in the record, and it should rise the level of being, considered more serious. And then lastly, before I turn it over to Andrea, is that I think that Alan's constitutional right to present a complete defense and to cross-examine Blair, to confront her. So his right to confrontation, I think they were both impacted. And I do believe that the Seventh Circuit, including a 2026 case, that although found it to be harmless, the argument is still there that it raises to the level of a constitutional violation. It raises to the level, depending on the relevancy, and I think the relevancy here is strong, that it rises to the level of a due process violation as far as the right to present evidence. And again, this was like I think Holt v. Boughton. Ultimately, they found that it was harmless, but we're just talking about it being an error at this point, and I think it is an error. And then Andrea.
I don't really have anything to add to that. I think the bottom line is that the state's identification of Richard Allen as the perpetrator was not a straightforward, eyewitness comparing a suspect to Richard Allen and determining that they're one and the same. Because nobody personally identified Richard Allen. So what the state did is used this indirect system where they said, basically, Betsy Blair and Sarah Carba, eyewitnesses, saw Bridge Guy. Bridge Guy equals Richard Allen. Therefore, all of these are the same people. And so for that to be true, then the descriptions of Sarah Carba and Betsy Blair need to not only be consistent with each other, which they were not, but also both need to be consistent with Richard Allen, which they really were not either. And so the fact that the identification here was indirect rather than direct does not make it less of an identification, just under the logic of how the state presented the argument.
Okay. Allison, any further remarks in your 15 seconds? I'll take that as a no. State.
I didn't realize I was muted. I was saying no.
I've got 3 or 4 things to say to that. First, the issue was waived because the sketch, I do not believe, was offered into evidence as an offer to prove. And so that's the end of the claim. But second, one of my friends on the other side was arguing due process. In Indiana, that's called fundamental error, which is a little broader than due process. And the defense has not argued fundamental error in the opening brief, and you cannot argue fundamental error in a reply brief. So the fundamental error / due process claim is gone. Third, on the merits, the proof that Richard Allen was Bridge Guy went as follows. I believe Betsy Blair did identify the picture of Bridge Guy or from the video that it was Bridge Guy whom she saw. And it was up to the jury then to decide whether that looked like Richard Allen or not. And I quite take my friends on the other side's suggestion that the identification was indirect. But at the same time, the jury had Betsy Blair's description of young, almost beautiful, poofy hair. So they could evaluate the without the sketch, the consistency of Ms. Blair's description. And
that's
well,
time.
I'm out of time. I'll
You're
stop
up.
there.
Defense. Response.
Real quick, I would just respond with, I don't think the argument that it wasn't made a part of the, there wasn't an offer of proof made. The purpose of that is to get it onto the record. In this case, that photograph was already highly litigated for several reasons, already a part of the record. And I think because it was thoroughly litigated, that it should be able to be addressed. And the purpose of the waiver doctrine shouldn't apply here, because the court did have an opportunity to address the issue and it was already made part of the record.
Andrea, anything further?
Nope.
Okay. Very good. This is directed to the state. Michael, let me see. So actually, you know what? This is another one to the defense. I'll get to you, Michael, in a second. Okay. So I want to address this one to Andrea, especially in light of your fantastic. Oh, I will. In light of your fantastic article that you just published on Substack recently. So, Andrea, the state says that he's a metallurgist, not a firearms examiner, and his testimony goes to admissibility, a court question, not credibility, a jury question. The trial court already, let me see, hold on, sorry. The court had already had ruled on admissibility. Should Tobin get a second chance?
Yes, he should, because his testimony goes to the weight that the jury should give the evidence, even if it meets the floor for admissibility as scientific evidence in the state of Indiana. Firearms analysis, as you know, these comparisons that are done between a forensic item like a bullet from a crime scene and a sample that they want to compare it to. This has been subject to scientific critique for decades, in part because of the criticisms of individuals like Dr. Tobin, who has been one of the primary critiques of the methodology and the extent of the conclusions that can be drawn from it. One of the challenges that you deal with when you deal with forensic examinations is that the validity of the evidence that's being offered depends very specifically on the claim that's being made, because a certain methodology might perfectly well support some claims, but be unscientific when expanded or applied to others. And the problem with the testimony in this particular case is that it purported to be able to match this crime scene bullet to Richard Allen's gun, to the exclusion of all other firearms in the universe. And one of the criticisms of this particular methodology, again, for decades, has been that far exceeds the scope of what the method itself can realistically produce. This has been recognized by several courts recently in Maryland, as well as in the state of Oregon. They have both recognized that claims purporting to state that a bullet was fired by a particular firearm are not scientific. Now, Indiana apparently will allow that testimony, but that doesn't mean that the defense then should not have any basis to be able to argue that that testimony should be given little weight, given the process that the analysts go through to be able to reach that conclusion. So, Mr. Tobin, as a metallurgist, is qualified to offer this particular conclusion. First off, because he is, contrary to Judge Gold's findings, he is qualified in the AFT process. So he is a firearms analyst. He is familiar with the methodology and the limitations and so forth. He's published articles on it. And so, to the extent that his testimony would assist the jury in understanding whether this conclusion is something that they should consider very strong and give a lot of weight to, or whether it's something that they should consider a little bit more questionable, is something that the defense has an absolute right to do as part of their right to present a defense. So it would have been helpful for the jury for them to hear some of the criticisms of this methodology and why. What makes it unacceptably subjective and unscientific for that reason, as well as what makes it over-claiming beyond what the limits of the analysis can realistically and scientifically support, to claim that a bullet came from a particular firearm. So because it implicates the right to present a defense and would go to the weight that the jury should give this evidence, Mr. Tobin, Dr. Tobin, testimony should have been allowed.
Allison, do you have anything to add?
I would just add that Tobin's, I absolutely agree. I mean, Tobin's testimony was directly relevant to the weight the jury should give to the state's firearm expert, which was a critical piece of evidence, physical evidence connecting Allen to the crime scene. And by excluding Tobin's testimony about fundamental flaws in the methodology used to match the cartridge to Allen's gun, the court prevented the jury from properly evaluating, reliable evidence. There was a recent case in Indiana, a state v. Smith, where the defendant raised a similar argument that the court committed reversible error by admitting testimony from the state's firearm expert, but excluding testimony from the defenses who challenged the methodology. And under Indiana's Rule 702B, which is supposed to be interpreted very liberally, that's the way the rule is supposed to be interpreted, it should be able to get in there. They ultimately found that it was a harmless error, but again, still noted that it was error because while claiming that excluding his own expert violated his Sixth Amendment rights there, I think there's an equal argument here, and I don't think it should be considered harmless.
Okay, very good. State, 2 minutes to respond.
First, I'll be mentioning this twice, not the waiver, but the lack of information about what Tobin would have testified to. The issue's been waived because there was no offer of proof, I don't believe, and my friends on the other side can correct me. There was no offer of proof what Tobin would have testified to. The second thing is that an appellate court reviews evidentiary rulings for an abuse of discretion, for discretion to have been abused. Basically, the court has to have been crazy on some fact or absolutely gotten the law wrong. And we don't even know if Judge Gull got any fact wrong because we don't know what Tobin would have testified to. And again, Mr. Allen has to show that his substantial rights were prejudiced, even if Judge Gull wrongfully kept Dr. Tobin's testimony out. But they can't show that because we don't know what Dr. Tobin would have testified to. So on this issue, the Mr. Allen loses.
Reply, Andrea.
Yeah, so I disagree as to the adequacy of the proffer because there was a significant proffer pre-trial as to both his qualifications and the testimony that he would be anticipated to proffer. Based on that, the state was fully aware he's a critic of AFT. The state laid out numerous of the aspects of his proposed testimony in its own brief. So this is not a situation where there was some kind of surprise to the state about what was going to be offered. There was sufficient basis in the pretrial litigation for that to be ascertained. So his question, his testimony clearly goes to the scientific underpinnings of the discipline in its entirety. And that's what he should have been allowed to testify to, because his other defense expert, Eric Warren, didn't offer that type of testimony. So it was not just cumulative.
Thank you. Michael, this question is addressed to the state. The audio from the movement videos, and I'm speaking obviously of the Westville prison videos wherein they were moving Richard Allen from place to place. The trial court let Allen show the videos, but required them to be muted. The state called this hearsay. But if a man is screaming for his father, if he's saying he's King Michael or King Richard, as it were, and asked to be cryogenically frozen, isn't that state of mind evidence not hearsay?
I will absolutely concede it is state of mind evidence. Unlike the state. No, I mean, if you're the state, you get credibility by conceding what you have to concede.
100%, and yet they don't.
and yet they don't.
All right.
I mean, it's the kind of thing that's relied on all the time. For instance, in capital trials, for instance, you have a psychologist and you have the statements of the defendant to the psychologist, and they come in all the time because the psychologist bases their opinion on those statements. They're not hearsay if they're not being offered for the truth of the matter, but for what the but I will say this. It may have been error to exclude them on hearsay grounds, but they also may not have been relevant, although relevance was never gotten to, because there are recordings of confessions by Mr. Allen where he sounds perfectly lucid. So absent some connection between the times that he's making these emoting on these videos and when he was confessing in the confessions that were so-called confessions that were admitted, it may be the audio may be irrelevant. Third, because the audio of at least some of the confessions make it sound like Mr. Allen was lucid when he was talking to Mrs. Allen, for example. The failure to admit the audio was harmless.
So let me give you a little pushback as the moderator on that particular question and answer. So you're arguing that, you know, in reality that you do concede the point. However, that the state could argue, but let me rephrase it. Isn't it true that the state could argue that it is hearsay, not because of the fact that Richard Allen's offering it in order to prove that he is King Richard or that he does want to be cryogenically frozen, but instead because that they're offering it to show that the truth is that he was genuinely delusional.
I don't think it's the way hearsay works.
Why do you say, is that do you want to handle the response?
No, I mean, there was a question to Michael, so I'm going to let him go.
Well, yes, I mean, I think it was being offered to show that he was truly delusional. I'll go back to a waiver problem. I know that the videos were entered, but I don't think there was even any offer of proof, was there, about what he was going to say in the audio, what the audio would say. And if there was, then perhaps the issue is preserved. But again, what I'm saying is, A, there's a relevance problem, given the apparent lucidity of some of the confessions that were entered. And there's also then the harmlessness problem, the failure to admit the audio that might show that Mr. Allen was delusional is harmless in light of the lucidity of the confessions that were admitted.
And I'll try to be quick because I want Andrea to chime in here as well. But I think that the state's argument that it just makes now, while I recognize that the appellate court can say that they can uphold or reverse on any ground, even if it's not necessarily the ground that the lower court excluded it for, I think that the state's very own statements here about, because there were these other recordings that he sounded lucid is just showing you more how much error, how much prejudice there was from it, because the jury was denied the opportunity to have a full understanding of the context and the conditions that led to his statement. And it also leads back to the other argument that the earlier phone calls were wrongfully excluded as well. I would say that it is reversible error, and that the critical question should be, what was the audio offered to prove? And again, the way hearsay works, it's not literally like, well, but overall you're trying to prove that this is true. It's literally, is that thing that he just said, the thing you're trying to prove is true? And the practical consequences of muting everything. The state characterized Allen's mental state during the confession and through this period as organized and concise. And it's the same thing the state is doing right now. That just proves that how significantly important the audio was.
I would just agree that the audio was relevant because it was offered to show the context for the confessions. To the extent that the state finds that context insufficient or argues it's not close enough in time or whatever, those are objections that should go to the weight of what the jury can do with that particular evidence. But it doesn't make it irrelevant. It's just an argument for why the jury should still conclude that the confessions were lucid in the midst of what otherwise appears to be a rather delusional state.
State, reply.
Yeah. The jury, and this is why, to the extent that it was erroneously excluded as harmless, also that the jury heard extensively from Dr. Westcott and also from Dr. Grassian for a slightly different thing, but heard extensively from Dr. Westcott about Mr. Allen's mental state over time in Westville. And the audio, nothing shows that the audio would have changed the outcome of this trial, that keeping it out prejudiced Mr. Allen's substantial rights. That's the language for reversal on an evidentiary ruling.
Okay. And a little bit of pushback. Is it the state's position that one's lucidity can be determined over a phone call and what they sound like? That's to Mike. That's the state's position. Okay. All right. Let's keep rolling here. Our next question is addressed to either one. You guys can raise your hand as to who wants to take it, but it's to the defense. I want to challenge you on the Odinism evidence. The FBI's BAU couldn't verify the theory. The consulting professor called the sticks fundamentally ambiguous. An actual Odinist said child sacrifice violates the religion. And Perlmutter admitted that she couldn't identify any other confirmed Odinist ritual killings. Isn't this evidence just speculation dressed up as expertise?
So I'll start, and I will say no. It is not speculation. So first off, these objections to the theory of Odinism are arguments to the jury for why the jury should disbelieve the theory, not arguments that should preclude the jury from being able to hear it in the first place. For the jury to be able to hear it in the first place, all that's necessary is an expert opinion that it provides a plausible explanatory theory for some of the aspects of the crime scene, the nature of the killings themselves, and the symbolism that is potentially visible in the configuration of the sticks. Now, the fact that the consulting professor was not able to identify exactly what runes the sticks might have represented, and from that, what the intended meaning of these configurations were. Nevertheless, the expert did believe that these were consistent. The placement of the branches was consistent with some type of runic communication. So the underlying theory of it was not something that was speculative on the part of the defense. It was supported by their expert. It simply has limitations, as many well-founded and properly grounded opinions often do. So these objections that you've raised, these are all arguments that the state was free to make to the jury for why they should reject the Odinist explanation. But that doesn't preclude the admissibility of that evidence in the first place for the defense to be able to present it as an alternative explanation for why the crime scene looks the way that it does. And because of that, to point out to the jury that it is less likely that Richard Allen, who has no known connections with Odinism, and whose, the state's theory of how and why he committed the crime doesn't relate at all to this theory, and potentially some of the circumstances on the crime scene as well. It allows the jury to compare the state's version of events with what they are able to see of the crime scene, and this alternative theory for why the crime scene might look that way. So it goes directly to the weight of the inferences to be drawn against Richard Allen from that crime scene, and should have been allowed.
But Andrea, sometimes aren't sticks just sticks?
Sure, sometimes sticks are just sticks, but when you have an expert that says these sticks could be runes, and for a variety of other reasons, this crime scene has characteristics of ritualistic killing, then it's up for the jury to decide if the sticks are just sticks or if the sticks are something more significant.
And I would say that the court's exclusion of this testimony prevented Allen, just as Andrea set out, from presenting a complete defense by establishing not only by establishing that the murders bore hallmarks of ritualistic killings inconsistent with Allen's involvement and consistent with third parties, or potential perpetrators. But it's very important that it also proves it's inconsistent with Allen's involvement. The trial court and the state try to characterize Perlmutter's testemony
Easy for you to say.
Right, as just third-party suspect evidence, requiring an identification of a suspect, with a demonstrated connection to the crime. Under that standard, the absence of a named Odinist at the crime scene was treated as fatal to admissibility. But Perlmutter was not offered just for that, to prove the specific identity of an individual committed the crime. She was being offered to testify that this was, in fact, or at least had signs of rituals in it. She's offered to testify that the crime scene contained observable features consistent with someone who had ritualistic knowledge or beliefs. That's categorically. Go ahead.
If I can cut in just real quickly, what Ali is getting at here is critical. It's the distinction between the SODI defense and the TODI defense, which are being conflated in the state's theory here. The SODI defense is some other dude did it. We're not pointing the finger at somebody individual. We're just arguing that there are circumstances that show it was not the defendant. That other dude did it is your classic third-party defense. You're pointing the finger at somebody specific, so it requires a heightened standard to be able to name that person in a public forum. But that was not what this evidence offered. It offered a SODI defense, and so should have been allowed.
Agreed.
Very good. Very good. State response, 2 minutes.
So Dr. Perlmutter's testimony and its exclusion was specifically preserved. I read that. First thing I'd say is, again, it's an evidentiary question. It's reviewed for an abuse of discretion, and I would tell the Court of Appeals to go look at her cross-examination at the third-party hearings in August of 2024, and from those, the court will conclude that her testimony was so bad that it was not an abuse of discretion to exclude her. But even if the court thinks that it was an abuse of discretion to exclude her testimony, it is absolutely harmless in light of, one, the confessions, but two, and maybe this is one, there is absolutely no evidence in the record that what Dr. Perlmutter was describing as a possible scenario is inconsistent with Mr. Allen having committed the crime.
Okay, and I want to ask a question, Mr. Ausbrook. In all your years of trying cases and litigating post-conviction work and your habeas work, how many times have you run into a situation wherein the judge disallowed any mention of a description of what the crime scene looked like?
Well, on the one hand, there's well, to answer your question directly, I'm not sure ever. On the other hand, the jury in this case saw crime scene photos, and actually, the state was permitted to describe the sticks as just sticks.
Okay.
Which, just to note there, babe, that's the, sorry, moderator, sir.
It's your minute. It's your minute.
That was the state conceding that it opened the door to allow Dr. Perlmutter in to explain an alternate scenario for those sticks that was not an undoing or just simply trying to hide the body. They offered two different things here. And I would just say that the state's own answer there about, well, now I forgot what I was going to say, so I'll let Andrea go.
I don't think that I have anything else to add.
All right, very good. Okay. So at this point, Michael, I want to talk about Holder's alibi. So Brad Holder, the state says that it confirmed that his alibi was airtight, but Allen's team deposed the HR officer and found that Holder did not have exclusive control of his badge and that anyone on the second shift could have swiped him out. And law enforcement declined to review surveillance video when offered. Is the alibi really as airtight as the state claims? And additionally, I want to add on there, isn't there also a possibility that the homicides did not take place at the time that you guys said it did?
Is this in the appeal anywhere?
Yes.
Is it?
I don't think so.
Well, I added the thing about the the timeline.
We're trying to make the appeal stronger. Is that what's happening, moderator?
No.
I mean, Brad Holder, my understanding is the the direct third party stuff, the direct third party stuff involving Holder was excluded because Judge Gull found there was no nexus. Now the state said there was no, that he'd been cleared, his alibi was okay. But I don't think there was ever an offer to prove at trial. I don't think it's in the appeal. It may be in the facts, but I don't think there's any issue in the appeal raised with respect to Holder's alibi.
Wait, let's get out of character real quick. I think the complaint, I got the brief right here, but didn't they argue? Oh no, I'm looking at the states that there was the exclusion of the third party suspect evidence was an error.
They did, but that wasn't so. Holder and his alibi, that wasn't preserved because they didn't make an offer of proof on that, I don't believe. And then you get to Westfall and what Amber, so you get what Amber Holder told Brad Holder is pure hearsay. And that's no good for third party stuff. And that's under the case cited by the state, Appellee v. State, which I know a thing or two about. So I don't know. I don't feel like that's a complete answer to the moderator's question, but I'm not sure. I mean, if you want to get into the third party evidence writ large, we can do that, but I don't think there's anything specifically raised with respect to Holder.
Okay.
Well, I want to comment on Holder to the extent that it is raised, because the court did not consider all the possible alternate perpetrator evidence when they're to demonstrate this connection. The court imposed like this categorical exclusion, and it didn't conduct like an individualized analysis as to each piece of evidence. And when we talk about, well, alibi has been confirmed, the state's brief did repeatedly describe Holder as having an alibi that was confirmed, making it impossible for him. But again, we had this evidence that shows that the badge was on a public rack, accessible to all employees without a lock. His name was predominantly displayed. He did not have exclusive control of his badge. An HR officer acknowledged that if someone else clocked Holder out later, that would not have been known. So the law enforcement, declined to even look at the review of the video. I don't know if the defense ever actually got it, but law enforcement didn't interview the other employees. They didn't establish his presence. Although what was real important, he was scheduled from 5 to 1:30, but his badge wasn't swiped out till 2:45 during a second shift with no explanation. That right there, it is like documented and unverified reliability, and this law enforcement chose not to investigate, and I believe it's important.
The only thing I have to add to this too is that there's a circularity going on with the reasoning that the alibi is quote unquote airtight, and that requires you to assume the state's theory about the time and the way in which the death took place. But we heard, of course, from the medical examiner that the time of death can't be identified any more precisely than just some time before the bodies were discovered. And so, if that's possible, then there is plenty of time in which Brad Holder. Brad Holder was not, demonstrably or even arguably at work or at the gym.
State, anything?
Yeah, I'm going to step out of my deputy attorney general thing, and the Holder alibi really sort of, and we'll obviously get to the headphones in a minute, but it's all one big ball of wax, and that is that all of this is only. A lot of this particular, the third party stuff only stays out if you assume the state's timeline.
Mm-hmm.
I mean, and the headphones kind of refute that, at least a little bit. And yeah, so, had an offer to prove been made, I understand there was this, whole third-party hearing, and we have, Brad Holder's Facebook stuff, but that wasn't, all of that was not preserved at trial. I do not believe the way Perlmutter's testimony, I mean, they specifically said at trial, is what we did enough to preserve the question? Is what we did back in August enough to preserve the question now? And Gull said yes. I don't think there's any of that with respect to anything else.
But Michael, just to ask you this, do you think the court could reason that the purpose of these waiver rules is so that the record is clear and there's something for the appellate court to lean on to see?
They'll say it's post-conviction problem, ineffective assistance problem, whatever problem. The only time, so the Indiana Court of Appeals will say with fair regularity, but the issue's waived, but we prefer to decide questions on their merits. And I have never seen that followed by anything but you lose anyway.
Right. Yeah, when they don't say that, it's when you might have won.
The Indiana Supreme Court, on occasion, in some really extreme sentencing cases, gets by. I mean, the Indiana, that said, that's the Court of Appeals. The Indiana Supreme Court, they'll do whatever they want.
Luxury. Luxury of being the high court.
All right, I'm about to rein in control of this debate as it's spun off completely out of control. All right, Andrea, why was Judge Gull not well within her rights to find that Officer Cecil's Google search during a 15-minute break was absolutely allowable in terms of the information he was able to provide, the invaluable information that he was able to provide to the jury with regard to the plugging or unplugging of headphones and whether or not that auxiliary port could be activated falsely by either water or dirt?
It was plainly error because the testimony about the Google search was plainly hearsay to such an extent that even the state is not contesting that it was in fact hearsay and that was an error on the court's part to rule otherwise. With respect to harmlessness, the evidence was particularly problematic because it allowed the state to improperly rehabilitate its timeline. And as we've pointed out, as Mr. Ausbrook just pointed out in talking about the whole ball of wax that constitutes this case, so many of these moving pieces and inferences depend on that very specific time frame that the state has alleged. This is the reason for assuming that Bridge Guy is the same person as Richard Allen, is the same person who could be seen parking at a particular time and so forth. That's very, very important for their explanatory theory of the evidence. So the problem is that when you have something that the explanatory theory can't account for, a fact that it can't account for, you no longer have a good explanatory theory. You've got a problem, and in a criminal prosecution, that problem can constitute reasonable doubt. That's what the evidence of the headphone insertion threatened in this particular case, is to undermine the state's explanatory theory that depends on a time frame that is flatly contradicted by objective forensic evidence. So because of the centrality that the timeline played in the theory as a whole, and the fact that this rehabilitation never should have been allowed, that seriously threatens to undermine the outcome of the case and the jury's consideration of the state's theory as providing a complete explanation of all the facts and circumstances that are presented concerning the commission of this crime. Because of that, it should not have been allowed.
And I'll only add to that because Andrea said all the things that matter, and usually does, by the way. But the other point to me of this evidence is that it was so completely prejudicial and irrelevant because it did not even speak to whether or not those things that he testified, the things that Cecil said might cause a problem, would in turn create the internal forensics to constitute that same problem as meaning that same thing. I don't think I'm explaining it well, but what I'm trying to say is even if that could explain the occurrence, right, of the jack not working, that in no way, shape, or form means that the Cellbrite or the software or the phone or whatever is going to attribute it that specific code because of that specific event. And there's complete disconnect with why the evidence was even offered in the first place. Did I explain that well? Did it make sense?
Made sense to me, but I'm just a moderator. State response.
So yeah, it's obviously hearsay, but the exclusion of it was absolutely harmless. It did not prejudice Mr. Allen's substantial rights. There is no more movement on the phone. There are Mr. Allen's confessions. And additionally, even if somebody at 5:35 wandered on down the hill, found the girls, and plugged headphones in, doesn't mean Mr. Allen, we have Betsy Blair especially identifying person she saw as bridge guy. The jury was free to conclude that bridge guy in the video or a still photograph, if that's what they were shown, was Mr. Allen. And it does not mean he did not kill the girls.
And let Andrea have the full minute response, babe. But I have got to say that is among a real possibility and a scary possibility of what an appellate court could say. All right, I'm going to assume that someone else went down there and plugged something in with the phone. That doesn't mean that person had anything to do with the, unaliving of the girls, and it doesn't mean that Richard Allen didn't commit the offense. It's something outrageous and ridiculous like that.
Well, that of course would be speculative. There is no evidence of any other person going to the crime scene to do this, and indeed that's part of the problem that the state faces with being able to explain this particular piece of evidence, because the state bears the burden of proving the significance of what it is presenting to the jury. And so if the jury can't explain the significance of headphones, wired headphones being plugged into the phone and taken out of the phone at 5:30 and 10:30 respectively, then the state has not offered a good explanatory theory, and those actions can constitute reasonable doubt that the state has got it right in its assessment of what happened.
Absolutely.
Okay. There's enough time for a surreply if you want, Michael.
No, I mean, to slip over to the other side, I think I've said all that can be said about the headphones. I mean, it's hearsay and was clearly hearsay. So the next question is, was it harmless?
And I think, what I got from Michael's answer before, and agree with Ali that, it's like, this is very likely, this is the kind of way an appellate court can go in deciding these types of issues, is just go straight to those confessions. No, it's harmless because he confessed anyway. And so the jury would have been within its rights to not consider anything at all but the fact that Richard Allen confessed, and give that, total weight over everything else. And therefore, any sort of discrepancy on the timeline theory wouldn't have mattered anyway. It's very possible, and it just depends on kind of the theme I've raised a few times with this issue, is how narrowly or how broadly do they look at harmless error? Do they look at it individually, each error by each error, or do they look at it comprehensively in terms of the case as a whole? And you can get very different answers depending on which approach you take.
Well, and I mean, at least dealing with the Indiana Court of Appeals, I mean, they are capable of saying sort of exactly what I said about, somebody wandered down, stuck headphones in. I had a case where
That's
they
alarming.
said an alibi. They literally said an alibi witness would not have mattered because there was an eyewitness to the crime.
Wow. Wow.
Yeah.
That person is walking around in the world now.
Thank gosh.
Really?
Crazy.
Yeah.
Well, I think he's saying that that person got off ultimately, right?
Yeah, we got a habeas writ from the bench from a judge who never granted a writ in his life.
In federal?
Yeah.
Of course. Of course.
All right. Okay. Do you guys, let me ask you this. Do you have any other questions with regard to issue 3 that you would want to touch upon that I did not touch upon?
Yeah, I did. There was a couple of things that I wanted to say. I don't know if I remember anymore, but we were talking about the audio. Did we ever talk about the exclusion of the April 3rd bookend calls?
Yeah, let's talk about that one specifically.
Okay. So I'm going to allow, what I'm going to do is allow you to address the issue, and then I'll give Michael the opportunity to respond.
All right, so I'm going to lay it out, and then Andrea can answer it. So, like I think it was like issue 2. I could be wrong, but the exclusion of the 3:12 a.m. and the 8:45 a.m. calls, that was we extensively discussed whether under the completeness doctrine and a fairness standard that those should have been allowed in to explain this so-called confession to his wife. So I think that explains what we're talking about, right? So
yes.
Go for it, Andrea.
Well, the issue here is that the jury was misled by not hearing the immediate context of those particular that particular confession. The fact that just moments before he was anticipating that he was losing his mind, and he was providing warnings, and then subsequently he's reporting that he didn't remember what he had said and didn't remember making the call, and so forth. So without having that context, the jury is getting the impression that this is an isolated, spontaneous, lucid, comprehensive confession to the crime, to the people that you would expect him to be accountable towards, and that's not accurate. That is misleading. So the scope of the rule of completeness to be able to offer additional statements to put the proffered statement into context, the limits of that are based on fairness. What is fair to fully and accurately communicate what was being said? It's not a question of semantics of like, how do we define statement? And therefore, when his mouth stopped moving, it stopped being a statement. It's all contextual depending on the nature of the communication. And so in this particular case, given the proximity and the relatedness of those immediate phone calls, that context, when you take it out, unfairly changes the strength and the appearance of the communication that the jury was allowed to hear. And so that's why the fairness standard of the rule of completeness requires that they should have heard the full context.
Yeah, and just to flesh it out, the 3:12 a.m. calls was to his father. He says he's losing his mind. He's, unsure for how much longer he would be lucid. He felt like he was being mentally tortured, like at Guantanamo Bay. He believed he was being drugged in his coffee and something about Kool-Aid, and insisted that his family knew he would never do what he was accused of. Then you have 2 hours later, 5:14, he calls his wife and says, I killed them eventually. Evidently, I did it, or something like that. And it was an equivocal statement. It was not sure. And then at 8:45, he calls his wife again, panicked, unsure whether the 5:14 a.m. call was a dream. and asking when his lawyers were coming to see him. So that's why what Andrea just described about, getting those two in to have some bearing on the 8:14 a.m. call or 5:14 a.m. call is so important.
The other last thing I would just add on this is that the doctrine of completion, this is an exception to the hearsay rule. This is one basis for offering it. But the defense, I believe, has also argued that this wasn't hearsay at all because, again, it's not offered for the truth of the matter asserted. It's not offered to prove that, there was stuff in the coffee or even necessarily that Richard Allen was losing his mind. But it's offered to show the context of his state of mind in the time frame when he is making this particular confession. And so because of that, it's again providing context in which to evaluate that particular confession. So either under the rule of completeness hearsay exception, or because it simply isn't hearsay at all, it should have been admitted.
State.
I think the only argument is that because it's separated out by 317 to 512, it's separated out by a few hours. It really isn't completeness. Otherwise the arguments my friends are making, especially the one that it's not hearsay, are entirely correct. And harmlessness, goes to the confessions. The only thing the state could say in that is there's a thing that deputy attorney general do, and they basically just say state wins, and
classic.
And no, what you do is you say, the admission of this, the failure to admit this did not, so we're talking about an evidentiary ruling, did not prejudice Mr. Allen's substantial rights, and let the court figure it out. You don't go into an explanation because it's really hard. We're talking about the confessions, which the confessions are going to be, what kills everything else. And now you're going after, the context for the confessions, which undermines them. I mean, this really is a one big ball of wax case. So anyway.
And then, moderator, I would also raise that the state makes the argument that the trial court properly excluded Dr. Gracian's testimony, that Allen's confessions were false because it violated Rule 704, which prohibits a witness from testifying about the underlying, like the whole thing, like the truth or falsity of the state's case. And Dr. Garrison was already permitted to testify about the effects solitary has and the symptoms of delirium. So I would counter that. Gracian. I would counter that by Dr. Gracian was not offering an opinion on Allen's guilt or innocence, but providing specialized knowledge about how the specific conditions of Allen's confinement could produce false confessions and delusional thinking. This testimony was essential for the jury to evaluate the reliability of Allen's confessions, which were the state's most compelling evidence against him, as we keep hearing the state relying on that for every single harmless error question. So, there are authorities out there that would support that because Dr. What is it again? Gracian's testimony was not offering opinion on Allen's guilt or innocence, but providing that specialized knowledge, that it should have been allowed in.
So I have an answer to that, and that is that Dr. Gracian could testify that under the circumstances, Mr. Allen's statements fit the profile of false confessions. He can't testify. He can't say these were false confessions.
Correct. But I
he
think
can say they're consistent with the characteristics of the false confessions, right. And the things that the thing that I thought was most like important about this particular piece of this particular argument and this particular offered testimony was how he was not allowed to explain the bases for his conclusion that Richard Allen was in a delirium and that these bore the hallmarks of the false confessions, because that included the evidence of, for example, Richard Allen made a whole bunch of statements of things that were false. And he, you know, for example, confessed to committing the crimes in ways that did not happen. And so these are types of things that are also, you know, quite important in evaluating how much credence do we give to what is, you know, coming out of Richard Allen's mouth. Is it true? Is it false? His reason for concluding you can't give weight to any of it relies in part on there's this totality of statements you have to look at and not just cherry pick out the ones that you like that are helpful to your position and say, you know, these are good statements, let me offer those. You have to look at the context as a whole, and that includes the statements that he was making that were not at all favorable to the state's case.
Yeah, and at the end of the day, under 704B, again, prohibits an opinion on the truth or falsity of the allegations, meaning the charging allegations against Richard Allen, not a clinical observation about what a patient said that turned out to be factually impossible. So he was not being asked to say Allen did not kill the girls. He was being asked, just as Andrea said, to identify specific false details as clinical evidence of confabulation. Like that he testified to, he was trying to be able to testify to the fact that
This should be sus.
Right, exactly. It's like the specific details, false details in Allen's confession, including like that he shot the girls and things like that. It's that this was a confabulation that is typically seen when these type of things happen. So it's a pattern. That this is a pattern of confabulation is a recognized clinical hallmark of delirium. And it's not offering an ultimate opinion that the confessions were in fact false, just clinical testimony about clinical observations, specific, identifiable, false details that support his diagnostic conclusion. So just like Andrea said, by not allowing him to say how he reached his conclusion, because we don't want the jury to hear he said false things, that's not how it works. This
Ma'am,
is
you're over time.
All right, sorry.
Sir, reply.
No, I mean, there's really no answer to that. They're not being, you know, his opinion. I mean, it goes back to what we were talking about earlier, and the audio of the video of Mr. Allen in prison. And I don't mean to take off my Deputy Attorney General hat, but I mean, the law is what the law is, and the only thing the state can really argue is harmless error, or I mean, Andrea was there. I don't know enough. I haven't fly-specced what was preserved and what wasn't. You know, what Dr. Grassian would have testified to if given the opportunity. Maybe that was all preserved. But it's just as I was saying earlier, in capital cases, psychologists rely on things that a defendant says as part of the mitigation case, and Dr. Grassian was relying on things that Rick Allen said, whether they were true or not. They're being offered for the basis of Dr. Grassian's opinion, and that's specifically permitted by the rules.
All right. And with that, unless either side has an issue that they feel related to relative to issue 3 has not been addressed, we're going to be moving on to issue 4, the motion to correct error. Is everybody fine with that?
Yep.
Michael, Andrea?
Yep.
Okay. All right. So as to issue 4 in the brief, this is going to be addressed. I'm going to go with Andrea here. Andrea, the state says that you cannot prove surveillance video timestamp is accurate because Allen himself acknowledged it's off. How do you prove Weber's testimony was false if your own evidence has a broken clock?
Well, that is definitely a challenge. The validity of the timestamps is an important question, and in this particular case, what tends to corroborate the timing of the timestamps on the video is the phone location, the ping evidence of when Mr. Weber returned home, when his phone began pinging off of his own property. And that tends to correspond with the timestamps on the video as well. So given those two pieces of evidence together, they tend to suggest that Brad Weber's report that he had returned home approximately, half an hour earlier or so, could not, in fact, be accurate. And moreover, that the state would have known that because they were in possession of these other items of evidence that directly contradicted it.
Habeas corpus?
Coming. So the answer, there is a, contrary to the state's argument, there is actually a foundation for the time, and that is under penalty for perjury. One of the investigators testified, filled out an affidavit saying the clock is 12 hours behind. The state did not. The state filed a response saying it's off. Mr. Allen then filed a motion to strike the state's response. That was denied, and there is no appeal of the motion to strike. So the challenge is in from Prosecutor McClelland. The court can conclude that it is off. We don't know how far it's off. The state says and therefore they didn't, and this is again all for post-conviction, or at worst the court needs to remand the case for a glossip hearing, which Mr. Allen asked for. There is no argument that this was harmless if it was a glossip violation, just none. And the state should have not made a harmless. It's just crazy.
And tell the people what a glossip error is.
Glossip is a recent case. The original case is Napoli, 1953. The state prosecutors, the government, is not allowed to put evidence that knows or reasonably should know is false. And let's just say Mr. McClelland himself personally did not know about the van video. He is charged with knowledge of everything law enforcement has.
Yep.
And so, state, what does that typically result in?
It would be an in trial.
Okay.
I mean, there is no harm. The state relied on the van explicitly in closing argument. The standard for reversal is the state has, and they really don't do this in the prejudice part. The state has, it's up to the state to show beyond a reasonable doubt that there is no reasonable possibility the glossip error, putting the van in, contributed to the verdict.
And that's impossible.
Yeah, exactly.
Exactly. It was the reason for the verdict. It was the thing that only the killer would have known, the detail only the killer would have known. So it was absolutely critical to the verdict.
Right. So.
And the state's suggestion in its brief that the timestamp could run, in either direction, like, oh, we don't know which way it goes. The defendant's brief explained that it was daylight during these hours and nighttime during these hours. So that doesn't flow from the daytime night image at nighttime display time discrepancy. So I don't even see how they're really.
Yeah, and I gotta say, I'm not happy with the daytime, nighttime thing. I didn't write that part.
I mean, at least it supports what the
Look, Matt Hoffman, one of their investigators, said it was off by 12 hours. He knows from the source of the stuff it was off by 12 hours. They should have, Court of Appeals would almost have had to take that as true if the motion to strike had been appealed. But because it wasn't, then there's this just personal statement by McClelland on the other side saying, yeah, we don't really know. And so the best the state can hope for out of this is, well, the very best it can hope for is, yeah, the foundation wasn't established. I don't think that's true. A foundation was established. You can argue whether it's sufficient.
Well, what is the state's rebuttal to the corroborating evidence, at least in my estimation, that Weber's phone links up or attaches to his Wi-Fi?
So the answer in the brief is you don't even know if he waited till he got home to turn his phone on. So you know, he could have driven by at about 2:30, gotten home, and then when he got around to it, turned his phone on. That's the state's actual answer, and it's not a bad one,
right?
And it's the kind of thing I would, if I'd been the state, I wouldn't have been arguing harmless error. That's ridiculous. I'd have been saying, you know, you ought to send this back down for hearing if you're not going to affirm.
What I think the state, you know, what I kind of expected them to lean on and was sort of surprised that they didn't, but you know, whatever, it is the just knowing falsity part of the NAPUI requirement and the glossip requirement. It's a high standard that a prosecutor not only that the evidence was wrong, but also that the prosecutor knew that it was. And that gets more complicated in situations where evidence is conflicting, because then what do? Theoretically, anything you put forward is contradicted by something else in the record. That doesn't mean that you know it's false. You're just, you know, having to kind of interpret the evidence and present the one that supports the position that you're asserting. So I think from a factual standpoint, that's where this case is slightly different than glossip and slightly different from NAPUI, which both involve circumstances where the prosecutor had access to information that contradicted the defendant's testimony, his trial testimony.
Or their witness testimony.
Yeah, the witness's testimony, but it also didn't. It seemed to be like pretty. Like that's it. It was directly contradicted. There's no dispute. There's no like back and forth about, you know, possible conflicts in interpreting the record and so forth. In this particular case, you have the challenge of these separate interviews with Brad Weber where, you know, he says one timeline and then he changes it to another timeline and then he changes it again at the time of trial. And then you've got the surveillance video and then you've got the confession, you know, to weigh in that corroborates his time frame and so forth as well. So that is what I kind of anticipated as an argument from the state that I'm kind of surprised we didn't get, is that the conflicts in the evidence here preclude a determination that the prosecutor knew that this evidence was false.
So they're actually in the trial record. I don't think there is any conflict of. I mean, they weren't allowed to impeach Weber.
So they weren't allowed to impeach him, but it did come up in the conversations about it and about if they were going to be able to call in the FBI agent and so forth. Like the context was presented in the record. That's the only reason I know it.
And Andy Baldwin is, I think, really, really lucky. Gull didn't let Poll in, because there's a statement by Brad Weber 2 days after the murders that he came home about 2:30.
Yeah.
And that would have been a prior consistent statement and destroyed the impeachment. But the example that I've used, and I think this fits pretty closely, and maybe not exactly, and that is the state there's a robbery, and the state puts on a witness who literally identifies the defendant in court. But there's a video of the robbery, a security video of the robbery, showing somebody that doesn't look anything like the defendant. I mean, yeah, that's a conflict in the evidence, but you can't, you're a prosecutor, you can't sit on that, even if the defense is asleep at the switch.
All right, I've lost complete control of this debate. I'm reeling you back in.
Because remember, it's hard to make Michael keep on his AG hat.
It was nothing I was looking forward to more than hearing Michael argue against his own motion.
It's the motion to
Well,
correct error.
I did argue. I mean, I think
Yeah.
I
You're
did.
not done, buddy. You're not off the hook. So just take a breath. Take a breath.
You can argue about the discrepancy in time. I really don't think, I think I disagree with, yeah, the state maybe should have gone after the knowing falsity, but I don't think there really is any actual conflict. You know, several conflicts in the record. Oh, I don't know which one is true. You got the video, and you rely on it. You rely on the phone data to say the girls were dead at 2:32. I just don't think. I think the state made the best argument they could about the foundation.
Mm-hmm.
Yeah, I mean, it really became the heart of their case. You know, and interestingly, and I'm slipping out of moderator role a little bit, I always think back to Andy Baldwin's opening statement, wherein he's like, I want you to pay very close attention, because at some point during the state's case in chief, they're going to change their theory completely. And they did. You know, it's like they knew coming in that it was going to be something that they thought would take the state by surprise. But ultimately, and I don't know if like what your thought on it was, Andrea, in terms of when they called Weber last, I felt that the defense was taken by surprise.
Mm-hmm.
I did not think that they saw that coming at all, you know, and
Yeah, I mean, it could have been. I don't know that I necessarily had that sort of read on it like you might have had, you know, because I was learning so much about the background of the case and everything kind of in real time as this was being presented.
Yeah.
What surprised me about all of it really was just the kind of rehabilitation of Brad Weber that kind of ultimately was able to be done, because his first time on the stand was just such a disaster. I mean, it was crazy the way he exploded on the stand, and I thought just gonna kind of like leave it at that and let the jury, walk away with this impression of, this guy.
That led into a weekend, right? Like that was a Friday, and then that was crazy.
And so credibility was potentially an issue after that. But then, he was called back in to kind of do the impeachment, since Pohl wasn't able to come in to do it. And then through that process, it became evident, I think, to me, that somebody on the state side had a little chat with Mr. Weber about how to comport oneself on the stand. And so his second time around testifying, he did come across, I think, as far more credible than he did the first time. So
night and day, frankly.
Let me say this about Mr. Weber's credibility.
Wait,
I truly believe that I truly believe
hat on right now, or not? No state hat right now.
You determine whether I'm wearing the white or the black hat. So he testifies that he got home about 2:30, and I truly think he wasn't lying about that. I think he thinks that's when he got home. When he's not telling the truth is when he says, I think he's asked, and Andrea, and you were there, Bob, he's asked, how do you know? And he says, I checked on my phone. And to start with, it's a phone he had 5 years later, because he was checking on the way in to see Mullen because they wanted to talk to him about this testimony. But let's just say he did check on his phone somehow. I didn't find out about it till later, but if he checked on his phone, he would have seen that he did not leave the Subaru parking lot until 2:12. He may have checked out at 2:02, but he didn't leave that damn parking lot until 2:12, which means he never got home at 2:30. And so he is not telling the truth that he checked on his phone to corroborate that he got home about 2:30.
Well, plus, I mean, that statement alone kind of destroys the state's argument that who's to say his phone wasn't turned off.
That's true. I checked my phone.
Well, no, he could not. No, he
turned his phone off and then turned it back. I get it, right? That makes sense.
I know.
He turned his phone off while he was, he's in the parking lot. He's in the parking lot, gets in the car, turns the phone off, drives home, and does something at the house, and then turns it on.
Yeah, I get
it. As one does,
Mr. Whitehead.
As like Brian Koberger did that, right? So,
Well, and I just want to say, I don't think there can be any argument that the van detail being something only the killer would know was the centerpiece of the state's, confession corroboration argument, that the evidence that transformed Allen's confessions from unreliable statements of a deteriorating man into proof bearing the hallmark of, genuine recall. If Weber's actual arrival time did not coincide with the window of the state's theory, they're the one who was putting out the theory. Their theory and their timeline needs to be proven beyond a reasonable doubt for this crime to have happened the way they say it happens. So if it didn't happen in that window, that detail corroborates nothing. And instead, it's a marker of confabulation, a detail drawn from whatever. It's been out in the public. Somebody said something to him. Did he even really say it? I mean, I don't know.
Huge parking lot. That's super.
Hang on. I mean, you all must be aware that Gray Hughes back in, I think it's March of 2023, just threw this thing out saying, wouldn't it be just crazy if it came out that Rick Allen had told his psychologist that he saw a white van drive by as he was killing the girls? And he repeated it and said, wouldn't that just be crazy?
Yeah.
I mean, the white van or the van, a van detail being around that area was on social media in numerous times before.
The white van thing was about something that happened in a different city.
But there were other vans driving by, a van here, a van there.
Here a van, there a van, everywhere a van.
Yes.
Yeah, I cannot impress upon you enough how that become that the van and the time of death, determining it by the phone stopping or the phone stopped moving, became the heart of their case. I mean, it was their closing argument. The girls were heroes because Abby's last act on earth was to hide her phone underneath her body.
With no blood on it.
Libby's phone. It was somehow Libby's act, but Abby kept it. Yeah.
Right. It was Libby's phone, but Abby had it under her body, even though the last person that was thought to have had it in their possession, at least based on what we heard, was clearly Libby. So sometime during the trip across the creek and during the murders, the girls switched possession of the phone between one another. So
along with the clothes.
Yeah, and the clothes too. All right, so let's get back to it. I've really lost control of this whole thing. All right, we're back to the state here. Michael, the state argues that Allen chose not to impeach Weber at trial and can't sandbag for a motion to correct error. But isn't there a difference between trial strategy and the state's independent obligation under Napui not to present testimony it knows is false?
Well, I mean, this goes to what Andrew is saying. Yes, the state maybe should have made the half-hearted argument that you know, because of the conflict in the time, and they rely on that, they didn't know it was false. I mean, that's how you actually do it. Because of the time was off, they didn't know it was false. It wasn't because there's a conflict in the evidence, it's because there's a conflict, possible conflict in the
clock,
because of the clock. But yeah, no, look, if the court finds that, you know, the case was made in the motion to correct error for the time on this, it's over for the state. You just, there's no, this sandbagging idea. I mean,
white hat,
yeah,
Michael.
they can absolutely sandbag. I mean, I'm sorry, sandbagging gets a bad name, but
Yeah.
there are a few circumstances where you can absolutely sandbag. That argument goes nowhere. The duty is on the state. It doesn't matter what the defense did, and to argue. They argue this case Freeman and say Freeman's case from the Seventh Circuit doesn't say anything like what the state says it says.
Michael's wearing the black hat again.
Wow. Can't keep his hat.
Well, no, I'm wearing the white hat because the state has arguments here. I'm not giving it up. I'm saying the arguments that were made are shameful.
Mm-hmm.
All right.
Then you're not going to give him the arguments that aren't shameful.
No, he shouldn't.
That's right. All right.
Well, not all of them. I mean, I think the waiver arguments are exactly right. I mean, they do a workmanlike job, but you know, to quote the BG video saying something it absolutely does not say, to quote, you know, cite the Seventh Circuit for stuff it doesn't say, to come up with sort of a prejudice argument on gossip
that'd be a gun.
I mean, they did it the whole trial. All of a sudden, the girls can't speak English.
Well, you know, I mean, look.
And look, you know, Stacey and Mark, their job, I mean, I think Andrea and I agree about this, is that, you know, appellate lawyers got to do two things. You got to make the court want to grant relief, and then you got to give them a legal way to do it.
Mm-hmm.
And even if the gossip thing isn't a legal way to grant relief, it's another thing, I think, at least on the evidence that's available, to make them want to grant relief. And
See, I think it's almost the opposite, which is like the irony, because I think it's, you know, it's legally one of the easiest ways.
Oh,
for
absolutely,
them to relief
absolutely.
If they decide they want to go that direction, but they have the big burden to overcome of having to find that a prosecutor knowingly misrepresented the evidence, knowingly put on false evidence. And given just the political universe in which all of these people operate, the judges and the prosecutors, getting a judge to make that finding is a real uphill battle. They will bend over backward to make every possible excuse that they can for the prosecutor to avoid the uncomfortable awkwardness of having to say something like that and then face other prosecutors, you know, in social and professional settings, and have everybody know that they made that finding and so forth. From the standpoint of getting them to want to, I think that the gloss-up is probably like one of the weakest ones for that reason.
Well, so I think what I was saying was that the gloss-up thing contributes to the wanting to grant relief. On one view, it contributes to the wanting to grant relief, and then you pick your adventure from the non-waived claims above, just because it makes it look like the state's case is completely false. But there is a way. I understand what you're saying about prosecutors, but in this case, you can absolutely soften the blow by grant relief on gloss-up by saying this: the standard is knew or should have known.
Yeah.
There's 20 terabytes of stuff here. Yes, he's charged with knowledge. It's a terrible thing that law enforcement, look, they brought on Brad Weber at the end about this. And from Mullen's testimony about getting Weber in, it really did look like a last minute thing.
Mm-hmm.
And basically they can say, you know, it's new or should have known, you should have known, you're charged with knowledge. Sorry, you lose. New trial.
All right, so here's what I'm going to do. I'm done with questions. I'm going to give each person what I'd like to hear from each of you. And Michael, sadly, you're still wearing the white hat, my friend. Andrea, I want to hear what your strongest argument that you would give, and you can make it as short or as long as you'd like, that you think would sway the appellate court at oral argument.
So when we came out of the appellant's brief, I had a perspective on which issues I thought were the strongest and most likely to result in relief for Richard Allen. And after reading the reply, my opinion on that really hasn't changed. And it's one or a combination of the third category issues, the ones that relate to his ability to present a defense. And so this includes things like the call, the context of the confessions, and the jail walk around videos, these issues with that we talked about with like Michael Grassian, Perlmutter, the third party culprit stuff, all of those issues, just because that is such a fundamental piece of the trial process, is being able to offer the alternative explanation and the alternative theory. And so this goes back to what I kind of hinted at and said a little bit earlier, that for an explanatory theory to be strong, it has to account for all of the known facts and evidence in the case. And, you know, because the presence of anything that disproves the explanatory theory means it's not good. The presence of things that call it into question might constitute reasonable doubt. And so the problem is that the sort of direction that this case took with these rulings is that rather than really weighing the state's explanatory theory of the crime against all of the evidence, the court just simply excluded the evidence that tended to undercut the explanatory theory, or that made it harder to explain, or that called certain parts of it into question. And so it serves this function of kind of implicitly bolstering the state's theory. And that really goes to the heart of what that protection, that constitutional protection is of the right to present a defense and to confront the state's evidence and the state's witnesses and so forth. So to the extent that those issues, you know, are not going to be found to have been waived, that there's adequate records of them and preservation in the record and so forth, I do think that there is enough there to justify a court looking at what was excluded, what was included, the Cecil hearsay, you know, all of these types of issues, and the effect that had of skewing the state's case and the perceived strength of the state's case, that rendered the trial process fundamentally unfair and fundamentally unreliable. Because yes, if you just take out all the stuff that contradicts your theory, of course your theory looks a lot stronger and people are going to be more inclined to believe it. He's entitled to a fair trial and he didn't get that because of those different rulings.
And I was just going to say, I agree with Andrea on the strongest issues here being just the inability to present a fair defense that touches on almost all of these things. And in light of, and Andrea said it at the end as well there, that when you look at the things that the state was able to get in that were erroneous, hands down, no one suggests that the Cecil evidence was allowed in. The allowing the Cecil evidence in, and even if there's a question as to whether the state engaged in some sort of misconduct by allowing evidence in when it had reason to know that it was not true, when you see how those errors affect are wrapped around and just compounded by the complete inability to present a defense. Again, you allowed the state to explain the sticks. You allowed them to give actual reasons, psychological reasons for the stick, and then prevented the defense from being able to give another alternative psychological evaluation. I think that they should, absolutely find that the exclusion of Perlmutter crime scene interpretation testimony was compounded by the state's own errors in admitting the evidence of another psychological reason, and that on remand, the defense should be allowed to admit the expert, crime scene interpretation evidence without requiring identification of a named suspect and without requiring a conclusion that it was in fact a ritual killing, because that's not necessary. And I would say that the same thing with, excluding the third party suspect. I know all the defense raised was Holder and Westfall, which makes me want to just hurt myself, but still. And I think that the cumulative nature of all of the errors of things admitted on behalf of the state and excluded from admission for the defense created, an unreliable outcome here, and that the integrity of the evidence and the identification of the defendant and the complete timeline was all in doubt, and that they should reverse and remand for a new trial that allows the Blair sketch-in, that allows the April 3rd calls to be admitted, the DOC audio to be admitted, Perlmutter's testimony to be admitted. I mean, all of these things. So,
and before the white hat goes, I have never in my life, and Michael made the argument that there were some of the crime scene photos, specifically of the bodies, and really they weren't of the bodies in terms of what we were really able to see. They really, after they showed, I think the pictures, correct me if I'm wrong, Andrea, but I think they showed the actual pictures only once, maybe twice, and then they kind of switched over to the sketch things. Do you remember that? Is that the case, or am I conflating things in my mind?
The photographs. So
of the girls.
There were they were shown I want to say on a couple of different occasions, because we saw them first from the crime scene. We saw the crime scene photos when the crime scene investigators testified, and so those photographs and everything were authenticated and presented that way. But then we also saw them again during some of the analytical testimony. So like the blood spatter analyst, for example, showed us a lot of the photographs again.
Yeah, and the concept of the defense having to tiptoe around the words that they used in terms of describing what a crime scene looked like was the most bizarre thing I've ever seen. Ever. Forget about Perlmutter not being able to come in. I'm talking about they could not give a description. They were barred from using certain words in terms of describing what the crime scene looked like. It was unbelievable to me. I can't think of any situation in any case where I've ever seen anything like that happen. And, I hope the argument was made sufficiently in the appellate brief. I don't know if it was, but it was shocking. I mean, and it is that thing that, that cumulative thing that when you just kind of look at everything that took place, I mean, it's so evident to the people on the outside looking in that he was denied a fair trial under the Sixth Amendment. But, I mean, Michael, I always defer to him when it comes to Indiana appellate courts and, what they do over there and what is their, habit in terms of these things. And it's like, we're obviously for people who very much believe that Rick Allen is factually innocent, so we were certainly biased in that sense. And, at the end of the day, I think it's hard for, any of us to kind of, because we don't want to diminish people's passion for the case by maybe suggesting that the appeal's probably not going to work. The direct appeals probably, at least that's what I think. I think that our hope lies in the post-conviction investigation, sadly. I hope I'm wrong. I really, really do. I hope I'm dead wrong, but that's just kind of how I feel about it. And, you know, I don't want people to lose hope if we're honest about what we think the chances of success for the direct appeal are. You know what I mean? And it's like, I feel like we try to do that because it's, you know, I think in Rick's best interest is that we want people to continue to want to fight. You know, I think it's important. I think that, you know, we want to have a movement and we want to keep the light shining on this case. So it's like, I think there's kind of, at least with me, there's that thing where I hate being the bearer of bad news, and a thing where I feel it's so important to continue to try to bolster confidence that this thing's going to get fixed, you know? So I don't know. White Hat, what do you got?
So here's how so Stacy and Mark would go first. Actually, before I put on the white hat, I just want to respond to what you said, and that is, it would always be a mistake to underestimate Stacy and Mark. And by the way, if there's an oral argument, I'm going to be tweeting repeatedly links to the YouTube video of Queen doing Killer Queen, because Stacy is certainly that. And so, you know, I have some hope that, and the reply brief's coming, and Stacy's terrific at oral argument, and I'm assuming, I think she'd be doing this one, not Mark, even though he did the original action oral argument.
Yeah.
So
before you put on the white hat, let me ask you this.
Your mic's a little higher. Are you on normal? Like,
probably
adjust?
It keeps putting me at like 144, like all the time. Yeah. See, I'm cranked again.
Yeah.
Sorry.
I meant to say something earlier, but
you guys should have. Michael, before you, I apologize for interrupting you, but how often are they not allowing oral arguments on these things? I mean, is this a case where you anticipate that they'll allow oral arguments?
Oh yeah, I think they'll ask for it. I mean, the Indiana Court of Appeals does oral argument extremely rarely.
so it'll be a good sign if they're granted oral argument.
Well, yes and no. They're going to grant oral argument because it's a huge, high-profile case. It's going to be more delay for Rick. I mean, if they grant oral argument, so their reply brief's coming in, I expect it's going to be at least a couple of months before they order oral argument. Maybe they'll do it faster, but at least a couple of months, and the oral argument will be 2 months out after that. So we'll have oral argument, and probably after everybody comes back in August or early September. And they'll probably take 3 or 4 months,
bless you, buddy,
at a minimum, to decide the case. And then you're into the whole transfer thing, which is, if you don't ask for a rehearing, you got 45 days to file a petition to transfer, and then the state has, I think, 20 days to respond. Then there's a reply, and I can almost guarantee you the Supreme Court will order oral argument, whichever way this comes out. I mean, we're talking really, I mean, even in the shortest time spans, I don't see this being over before the first few months of next year, and that's probably early.
Okay. All right. White hat us out.
So, you know, my answer, so Stacy and Mark or my friends went first, and the way so they'd had their 20 minutes. What I would be doing at the end of the oral argument for the state is really the only thing the state can do, and say, Mr. Allen convicted himself. He put himself on the bridge at the relevant time. 2 people said they saw bridge guy, the person in the photograph or in the video, Betsy Blair and Sarah Carbaugh. The jury was free to conclude, having seen Mr. Allen, that that was Mr. Allen. you have the gun evidence, you have the confessions, all of the non-waived errors individually or cumulatively are, under these circumstances, absolutely harmless beyond a reasonable doubt. The evidence against Mr. Allen was overwhelming.
The end.
The end. All right. So I imagine we're going to hear something a lot like that. All right. Well, I adore all three of you. Obviously, Allison the most because he's my best friend. But I love both of you guys. Thank you so much for your time and for letting us pick your big, beautiful brains. It's always such a treat to hear it. You guys got anything coming up? Andrea, you got anything that you wanna throw out there? You got anything interesting happening over at your house?
Well, we've got the Tyler Robinson hearing, the next one coming up on Friday. So I will be live streaming that. We've had some new developments, and I've had some things in the works as well. So I'm hoping, cross my fingers, to get out in the next. Well, I guess we're down to tomorrow. So by tomorrow, get down a little bit of a review of the motion that is the subject of tomorrow's hearing, which is the motion to exclude the cameras from the courtroom. It is interesting because it's relying on some of the same jury bias kinds of considerations that came into Brian Koberger's case when they requested to change trials, change venue. And so it's an intriguing position I think the defense is in, because what I think we're finding is that the Constitution guarantees certain things, and those things in the current era of how news is processed may not be able to be reconciled. We may not actually be able to give both free access to the courts and a fair trial to defendants. So it is a very interesting, and I don't want to minimize the issue just because I'm like all for cameras in courtrooms and stuff like that. Very much understand why the defense doesn't want them there. Yeah. So anyway, plan to try to get something out before tomorrow, by tomorrow, to kind of outline the motion that we'll be hearing the evidence about on Friday. Had some new evidence come out today about some of the ballistics and the new testing and things like that. I'm working on some things on Substack to kind of process some of that information as well. So that's what to look out for in the short term from me.
Nice.
Okay, cool.
While I've got you, Andrea,
yeah,
I want to, since you spend so much time thinking about cameras in the courtroom.
Yeah.
To me, my only objection cameras in the courtroom is, I think it is unfair to have any shot of the defendant. Mm-hmm. And I wonder what, I mean, that is pressure that should not be there. Mm-hmm. You want to have the witnesses and the judge.
Michael, or are you talking about a trial?
I'm talking about a trial. Even the idea that the world is watching. I've been charged with something awful. The idea that the world is watching me and how I react to this, that, or the other thing, to me seems incredibly unfair. Mm-hmm.
I think there's two parts to it. I think the first part is that, at least when you're talking about trial, the defendant's courtroom presentation is part of what the jury gets to see and observe and take into consideration. So to the extent that cameras are kind of intended to show us what the jury's decision is based on, one could possibly make an argument that the defendant's demeanor and presentation and everything is an important part of that kind of verification for the public's interest in the process. But when it comes to the pretrial litigation and stuff like that, I think there's probably a better, a stronger argument to be made to keep it out, because we don't have a jury present, evaluating it and stuff. The real problem that the defense is highlighting with the cameras is not so much the specifics of what they're capturing, as much as it is just the information ecosystem as a whole. The defense doesn't really take issue. I mean, the defense clearly does take issue with the cameras, but what the defense really doesn't like is how much attention is focused on this case. And the cameras provide fuel for more and more things to be talked about and spun off. And that's particularly the case when you have images of the defendant, and then everybody is going to be, a body language analyst and look for, minute expressions and things like that. And that's exactly the type of thing that the defense is concerned about blowing up and biasing the jury pool and just kind of creating the sorts of impressions that are very difficult to overcome later on. So it is, it's a complex issue. I really do understand very much where the defense is coming from, but it is, a challenge to weigh that against just imagine what the state would be doing. We see what the state does in cases where we get to be there and see with our own eyes. Imagine if there's no eyes on the state, the kinds of lengths that they would be going to and what trials would look like under those circumstances. So it is a very difficult question, I think.
It is, and it's fascinating, though, because, if you look at say, for instance, the Richard Allen case, aside from kind of our tiny universe, which really knows about the case, if you were to ask somebody in California, they'd never heard of it. This just wasn't a case where I think for all intents and purposes, it was probably had every element that would make up a type of case that would really draw the public's interest, just because of everything from the imagery of the bridge and the two girls on a school day and just everything that surrounded it, right? It had all the elements that true crime people love when they're looking for a true crime case to follow. And the fact that it wasn't, because she tried it in the dark, it really did limit. And we still saw it, even on the limited basis. And it's kind of to Robinson's attorney's argument, even in that limited scope, we still saw it, with people saying that I was like a shill for the defense and that the murder sheet were shills for the prosecutor and they were feeding information. We just talked about it 15, 20 minutes ago with Gray Hughes. How is this guy coming up with this information about this van? And wouldn't it be crazy if, clearly
it's not just the van, it's the psychologist.
I know. Yeah. It's both. It's both things. It's so it is a fascinating subject area, and it's really one that I think has to kind of be addressed moving forward, like as a whole. And to kind of Michael's defense in terms of the camera being trained on the defense is what the issue is. Because to your argument, Andrea, obviously the jury has the ability to be able to look over when a certain answer is given, say by a witness, and they're going to look over at the defendant and, see what their response is or might be. I think what Michael's talking about is when you have these cameras that are trained on a defendant the entire trial. So sometimes you'll see it where they've got just the defendant's face plastered for the entire trial. And then they'll have a separate window where they've got the witness up there. And in that situation, because I've seen Michael jump in my chat, and he takes great exception to people like poking fun and saying shitty things about, what the defendant's looking like in a given moment. You know what I mean? And I think there's some validity to that. I truly,
especially in capital trials.
Yeah. Yeah, look, I'm always trying to explain to people that the reality of that situation is it's just there is no winning as a defendant. There is no way to look. Well, it's never going to win you any points, because stone face means you don't have any emotion and you're an emotionless golem.
Yeah, no, you can't win in that. But to answer Andrea for a minute about, the jury gets to see his demeanor. Yeah, but in a previously public trial, the gallery's not sitting in front of the defendant. They can't see. They might be able to see movements to the side, but they're not looking at the defendant's face unless the defendant turns. I just think cameras on defendants. I just view it as bad business.
I get it. I
believe the one juror we've heard from. Rick's crazy eyes had a real impact on the one juror we heard from in the Delphi case. You know,
Yeah.
I mean, she clearly, you know, whether or not that was, but, you know, she was terrified of Brad too. So she thought Brad was the scariest guy in the courtroom.
Brad was kind of scary. I'm just saying that explosion was like, whoa.
All right, Andrea, I know you got to run. I know you got plans at 8:00. We adore you so much. Thank you again for coming and hanging with us. We always really appreciate it. Michael, same. I'm scooping him up. I think Michael's gonna join me for my Bob Ruff thing over on Tuesday. And I know, Andrea, you were hanging out with Bob recently too. So Bob's coming over to our house. We're going to talk about that Christopher Bynum case. So you guys can check Michael out again over here on Tuesday, next Tuesday. And then hopefully I get my beautiful and brilliant co-host back here in the next few days. I'm hoping.
Yes. Yes. So let's wrap this up.
All right, you guys, I'm going to let you go while we go through whatever supers we may have gotten. All right. Thank you guys both.
Thank you guys. We'll see you soon.
All right.
Go lick my
Bye,
wounds.
All right. Bye.
And babe, I'm leaving you.
Oh, there she goes. It's all right. I only got a few anyway. All
Okay.
right. So
Love you guys. Bye, everybody. Bye, babe.
Bye. All right. So new members, we got Rhonda, 6110, new member. We've got Lynn. Is it? Wait. Yeah. Lynn Ervard. I'm fucking that up. I know. Yeah. I feel like Allie. Ervard or Steve. Ervard. I'm just going to go with Lynn. Lynn. Just know I love you, even if I'm butchering your last name. If that is your last name, it's hard for me to tell. And both of you, family hugs. Welcome, welcome, welcome. Thank you for becoming members. We truly appreciate it. Justin, yo, loser guy. Member for 10 months. Free Richard Allen. Sorry for yelling. I'm all about it. And thank you. Thank you for your continued support. We appreciate that. Quantum Girl E, member for 25 months. She's got her 2-year like OG badge, right? Quantum. So happy to see I'm never moving away from Richard Allen. It's not happening. It's always gonna when I'm saying that I'm trying to be a realist, that doesn't mean that I'm giving up. I always thought, and I hope I'm dead wrong on it. I really do. I hope I am dead wrong. I hope that this thing is reversed and then remanded, and I hope he gets a new trial based on the direct appeal. I'm just girding myself towards, I'm hoping for the best, but planning for the worst is basically what I'm saying. So, Christina Jarvis, thank you so much. Michael, Andrea, Bob, and Allie in the house. The best cranks together. Love from British Columbia, Canada. Free Richard Allen. Thank you so much. Christina, Truth and Transparency, officially a law student. Back up, you two. Nice panel. Wait, what does that mean? Did you apply to law school? Is that what's happening right now? What's that? Tell me more. Tell me more. If so, congrats. That's awesome. Super proud of you. And then Kitty Koo, new member. Family hug. Thank you, thank you, thank you so very, very much for that. We appreciate it. We appreciate it. All right, you guys. I love you all so very much. I'll be back tomorrow for day 17 of the Zach Adams trial, which there's 800 of you in here who apparently give a shit about wrongful convictions. You should probably care about Zach Adams because that one, I'm pretty sure, I feel, knock on wood, I feel like he's going to get a new trial. And it's worth your time checking it out. You're late, but I've got 16 other lives you can go back and watch. So hopefully I'll see you tomorrow. Mods, I love you for double duty today. Thank you, thank you, thank you a million times over. And to all you beautiful human beings, thank you so much. Because remember, without you, I'm just an old man talking about all kinds of cases. See you tomorrow.